So, using Article 8, we've been able to challenge successfully stop and search powers that allowed people to be stopped and searched without suspicion. And you might think that that is dealing with suspects again, and not something that would appeal to the wider public. You'd be wrong, because you're forgetting once more the excesses of anti-terror laws in particular that didn't just affect a small group of foreigners in Belmarsh prison, began to affect all sorts of other people as well. And this is when people began to wake up and the complacency stopped. There's an infamous power of the Terrorism Act called Section 44 that allowed whole areas of the country to be designated in secret for stop and search without suspicion. If it was expedient, not even necessary, let alone proportionate, it was thought expedient to preventing acts of terrorism. At the height of the Iraq War, whole counties of England and Wales were designated for stop and search without suspicion, in secret, on a rolling 28-day basis. And the application of the Chief Constable and endorsed or rubber stamped by the Home Secretary of the day. And this began to emerge on the ground, normally in relation to peace demonstrators. And the big test case really arose a few weeks after I started in my job as Director of Liberty back in 2003, when there was an arms fair at the Excel Centre, the Docklands in London. And reports began to appear on the TV. We began to get phone calls to our office that peace demonstrators were being prevented from getting anywhere near the arms fair, and they were being prevented by the police under anti-terror powers. We phoned the police and they said, don't be ridiculous, we would never use Terrorism Act powers against peace demonstrators. And yet the reports kept coming. And I asked some colleagues to go down, they literally, one went down on his bicycle down to, because that's what public interest lawyers do, they get on their bikes, don't they, down to the Excel Centre and came back with a great big pile of these notices under Section 44 of the Terrorism Act. And of course, it emerged through that litigation, which went on for years. We sort of, won a little bit and lost a little bit in every domestic court. In the end, went to Strasbourg. Through all the years of that litigation, we were able to, and this is incredibly important, I think, for the wider operation of the Act, to begin a public debate about stop and search without suspicion. Because yes, it was peace demonstrators, and therefore it was people of every class and every colour and different categories of age and old ladies and all the rest of it. But of course, as we know, it's always a stop and search, predominantly young black men. And I think it's incredibly important now, as a result of the case of Gillan and Quinton against the UK, we've got prospects to really tighten up stop and search powers elsewhere in Europe, and certainly elsewhere in the British statute book. The DNA database, something else we can boast as the biggest in the world. Anyone who'd ever been arrested, had their collar felt for anything, whether they were ever charged or convicted, can go on the DNA database forever. But again, incredibly intrusive, disproportionate, and impugned under Article 8 of the ECHR. Now, I had a nervous moment the day after that judgment in Strasbourg, I have to tell you. I went to my Daily Mail, as a good human rights campaign should do, and I opened up with some trepidation. How would the report be? Because the newspaper had been against this kind of terrible intrusion into personal privacy on the one hand, the newspaper very hostile to Human Rights Act, ECHR, and those Strasbourg judges on the other hand. Which way would it go? What was the headline going to be? Was it going to be judges make us less safe? Was it going to be rapists will walk free? Mercifully not. Big brother humble. Interesting. Inherent contradiction sometimes, but that's okay. They're not governments, they're just newspapers. Even a stopped clock tells the right time twice a day. And of course, another brilliant Article 8 case that exposed the nature of unchecked surveillance in Britain. A case involving Poole District Council that decided that its local bureaucrats and functionaries should have a more interesting life and play James Bond and use targeted surveillance to check whether people really lived in the right school catchment area. Yeah? A nice middle-class family followed around for days and days with people playing Starsky and Hutch from the local council, staking them out and so on, and again, able to challenge that decision in the appropriate tribunal, but using Article 8 of the Convention. You know, this is popular, common sense stuff. You might say a British Bill of Rights with common sense. And further cases on conscience, on speech and dissent. And perhaps the key to the kingdom in all of this, I think, has been Article 14, the equal treatment provision. Because, I don't know about you, but my experience is that we all actually do love human rights. Not just people here who I'm expecting, but everyone I've ever met, to some extent, has an instinctive love for their own human rights and those of their family. It's just other people's that are problematic. My speech is free, yours is a little bit on the dear side. But Article 14 has been the great discipline, in my view, in the convention system and in the Human Rights Act in terms of the legal and political discourse elsewhere. With all of that proportionality and all of those legitimate interferences with qualified rights, what's to stop political communities always trading away the rights and freedoms of the vulnerable minority that has no power at the ballot box? Well, what's to stop them is Article 14. The discipline. It's a legal discipline and a political discipline as well. It's where law and politics, I think, really come together to force the electorate to imagine that this policy is going to have to apply to them and their family too. And I think it's philosophically and practically, in so many ways, including the Belmarsh case and lots of other cases, the key to the human rights kingdom. So just briefly then, we have this current debate in Britain at the moment. It's pretty toxic. It's full of